Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3079, United States of America versus Azam Doost, also known as Adam Doost, also known as Mohammad Azam Doost, also known as Mohammad Azim, Appellants. Mr. Schwartz for the appellant, Mr. Meisler for the appellate.
Good morning, counsel for appellant. Please begin.
Good morning. May it please the court, my name is Aaron Schwartz on defendant appellant Adam Doost. The reason we are here today is because the district court sua sponte and improperly raised a statute of limitations argument which the government had waived. The district court then denied the defendant's post-trial motions based upon the same issue in which it improperly raised. The district court had no authority to raise Clause 3 of the Wartime Suspension of Limitations Act. It was not raised in the government's brief, and it was not raised during oral argument on the post-trial motions.
So you draw no distinction between a waiver and presenting part of an argument and adding to it?
So, Judge, thank you. I think what happened is that initially the district court itself, as you said, raised Clause 3. The government initially only argued Clause 1. The string of cases that I'm relying upon about the district court's authority, they talk about forfeiture and not waiver, and clearly the government failing to raise it in their briefs or during oral argument and before the first opinion was released in this case, that was a waiver. And so the district court was out without authority.
If it were a forfeiture, then what?
If it were a forfeiture, I would refer to the Malouf versus the Islamic Republic of Iran case out of 2019 DC Court of Appeals. There are very narrow, limited circumstances in which the courts can intervene. And actually, another case, US ex rel Totten versus Bombardier Corp, says that the situation here, the government failing to make a number of arguments would not be an exceptional circumstance to the point where the district court could step in and essentially defeat the statute of limitations claims that we were making.
Usually courts have discretion to excuse forfeitures. Why shouldn't we think of this as a question whether the district court abused its discretion, and in thinking about that question, take account of the other point Judge Rogers made, which is they did preserve a Clause 1 argument, and frankly, there's not that much difference between these three clauses as I read the statute.
So, Judge, first of all, I would resort back to the fact that I think that it was a waiver that occurred. Mm-hmm. I think it's pretty clear in this circuit that an argument not raised in a reply brief is waived. And you know, whether it was an abuse of discretion, again, there's a two-part test under Malouf. And the first is, you know, were there institutional interests of the judiciary implicated? And, you know, I don't think so. It's certainly not in a criminal case. I believe that the defendant is, you know, the most important here over, you know, judicial economy. The second part of that test is if both parties are present in the litigation. And again, Malouf states that the statute of limitations exists to protect the defendant. So, you know, whether it was an abuse of discretion, I'm arguing that it completely lacked authority to intervene and basically violate the party presentation doctrine. You know, the government is supposed to submit arguments, the defendant submits arguments, and the court acts as a neutral arbiter. And that didn't happen in this case. And it would have been one thing if it was an issue that was raised and maybe addressed, but this was the sole issue that the district court relied on to deny the defendant's claims, the ineffective assistance claims. And so that's why it's so important.
Oh, do you want to push back on the suggestion that there's really not much difference between the three clauses?
Well, the district court held the clause 1 did not apply. Obviously, we're not challenging that. I do think there are important differences. I think clause 2 addresses surplus property, real or personal property. And of course, the loan funds at issue here didn't apply, don't apply. And, clause 3, should be narrowly construed in favor of repose. And, there was no rational nexus. There was no direct connection or direct relation to the authorized use of the military forces.
In your research on clause 2, while I understand your point that the legislative history ties it to the Surplus Property Act, have courts limited clause 2, or is there any suggestion it should be so limited?
The courts that have addressed clause 2, they didn't really perform a lengthy analysis.
Yeah.
But, I don't think that the statutory history should be, completely ignored. The Supreme Court's touched on it a number of times. And it's pretty clear that clause 2 really only applies to movable property. It was to make sure that chattel that was being used in wars could be disposed and even given to veterans that needed, certain types of property to begin farming expeditions.
How would you distinguish our cases and other circuits that say money is personal property?
The case I cited in my brief, I thought was pretty on point. There was a Seventh Circuit case as well that talks about when a statute references only money. When a statute references real or personal property, that's narrowing it down. I'm trying to find the case. It was a district court case in this circuit, but the case in the Seventh Circuit was the Seventh Circuit Court of Appeals. And I think it was if the court doesn't mind, I can find the citation.
All right, well, when you come back on rebuttal, if you want to point us to it.
Yeah, I mean, it's in the brief, but I hope does that answer your question between the distinction of each clause in the WSLA?
Yep.
Okay.
I understand your position.
Sure. So again, it was ineffective assistance of counsel to not challenge any of the clauses. There was no case law research performed on either clause 1 or 2. The trial counsel took the statute at face value and failed to recognize that there had been decades-old Supreme Court precedent that addressed the elements test, which the district court agreed with in clause 1. Because trial counsel did not conduct a reasonable investigation, there could have been no strategic decision to not challenge the indictment as time barred. So
what about counsel's explanation of how he viewed the charges and the interconnection of the wire fraud charges?
Again, Judge, he took the statute at face value and didn't do any case law research.
Well, I'm not sure that is necessarily dispositive of an ineffective assistance of counsel claim. I mean, we have taken the position that if there's nothing out there, it's not necessarily a burden on counsel to be.
Well, Judge, I would point you towards the Abney case, United States versus Abney. The question in that was, whether counsel failed to seek a benefit for his client based upon one of two reasonably likely but uncertain interpretations of a statute. And that's really what happened here. There wasn't even a challenge to begin with. And of course, the fact that we did win on the first clause, shows that it was prejudicial and obviously resulting prejudice.
Well, what about counsel's explanation in terms of the wire fraud counts?
So we didn't, initially we did challenge the wire fraud accounts. They're not at issue here because we do concede that there's an element of fraud that would put them under clause 1. But I think what you may be referring to is his analysis of the money laundering counts, which he relied on the specified unlawful activity of being the fraud. But of course, the elements test focuses on the statute, not what the specified unlawful activity would be. I do see I'm out of time, so if I could either reserve time for rebuttal, or I can obviously continue to answer your questions.
Let me be sure my colleagues, whether they have questions they'd like to ask now.
All set. Thank you.
Yeah.
All right,
Thank you.
good. So we'll give you a couple of minutes in rebuttal.
Thank you very much.
All right, counsel for Appellate.
Good morning, Your Honor. May it please the court, Scott Meisler from the Department of Justice on behalf of the United States. Can all members of the court hear me okay?
Yes.
Thank you so much. I'll address the statute of limitations issue, which of course we believe has to be resolved through the lens of ineffective assistance of counsel, through the Strickland two-part test showing deficient performance and prejudice. And I guess I'll begin, Your Honor, with the point that Mr. Schwartz started with, the waiver or forfeiture issue. We don't believe under the Supreme Court's decision in Wood versus Milliard, which is the main authority the appellant has invoked, that this amounts to a waiver in any way. Wood was a case, Your Honor, where the state in a habeas corpus proceeding had acknowledged in the district court the availability of a possible statute of limitations defense against habeas corpus relief, and basically explicitly elected not to raise that and asked the court to resolve the issue of the case on the merits. And then the appellate court, for the first time, asked the parties to brief statute of limitations and resolve the case on those grounds. This, I think, is quite different. As the members of the court have pointed out in colloquy with Mr. Schwartz, the government did raise the WSLA here, and it raised clause 1. At a motions hearing, the district court expressed the view that this case was perhaps best resolved under clause 3. And when it issued its memorandum opinion, it indicated that it was not inclined to address clause 3 without giving the defendant, Mr. Doost, a chance to brief the issue. And so this is a case where,
as I understand Appellant's argument, it's, and I tried to push back on this, assume it's a forfeiture. As I understand his argument, is inappropriate, an abuse of discretion for the district court to suggest a defense that the government itself had not suggested. It cited the statute, but it wasn't relying on clause 3.
Yes, Your Honor. I don't think, if that's viewed for the abuse of discretion framework, I don't think it's an abuse of discretion at all, where the court raises it, the government, and then both sides, Your Honor, have a chance to brief it. Right. That to me is the main difference here. Is this is not a situation where the
thinking of counsel preparing for trial, figuring out what arguments to present, what witnesses to call, what documents to introduce.
Yes, Your Honor, but I think this is different, because this to me seems like a legal argument under a tolling statute that's raised after trial. You don't have that issue of preparation. And again, the court, I think, ameliorated any risk of prejudice by allowing both sides to brief the issue and only deciding the question afterwards. And in fact, Your Honor, the court ultimately received, I believe, 2 rounds of briefing on this, because it first issued an order where it held that this tolling issue was properly one for the jury, and then only on reconsideration after another round of briefing did it ultimately decide the prejudice question that turns on the construction of clause 3 of the WSLA. So I really don't think there's any kind of prejudice. And if the court is looking at this as a forfeiture in the court's discretion, I think the court should find no abuse of discretion in these circumstances.
there may not be prejudice because everyone had a chance to brief Clause 3 after the district court raised it. But what's the justification for the district court injecting this new issue into the case? Normally, we do enforce forfeitures, and there has to be some good reason to excuse one.
Well, I mean, here, Your Honor, recall the posture of this case. This is one where these are issues being raised through the lens of ineffective assistance for the first time after trial. And I think that's one distinction. And I think under a number of cases that I wish I had handy but don't, I think this court has, and the Supreme Court have a number of times said, when a legal issue and a statute are raised before a court, the court is not usually limited to the exact arguments the party makes under that statute. This is not a situation where a court is injecting something entirely new into a case. As Your Honor mentioned, differences may exist among the clauses of the statute, but they're at times subtle. And so I don't think it's outside the range of district court discretion to tee up an issue that hasn't been precisely identified by the parties, especially when the court gives both sides a fulsome chance to address the issue.
Can I ask you, let's assume preservation on both sides. So the defense timely raised limitations. So we take out the IAC overlay, and you timely raised Clause 3 as well as Clause 1. On those assumptions, do you disagree with the district court that on those assumptions this issue would have been submitted to the jury?
I think that's a very close and hard question, Your Honor, in light of this court's decision in Wilson that the court discussed at length. In our briefing below, in response to the motion for consideration, we said that we thought the court's position on this issue was reasonable. I think it's difficult because
it seems like the applicability of the statute or not is part and parcel of a statute of limitations defense, which is normally a merits defense that a jury would resolve, correct?
I think it depends, Your Honor. I mean, to my mind, these issues exist kind of on a spectrum where you have, for example, withdrawal.
Assuming the facts are genuinely disputed.
I still think in some cases, even if the facts are disputed, the application or not of a tolling provision can in some instances be decided by the court pretrial, like in the Flores case from the Second Circuit that Mr. Doost decided on the fugitive tolling provision. So that's why I was saying before, I think these exist on a spectrum where you have, for example, consummation of the offense during the limitations period or withdrawal from a conspiracy that would render an indictment untimely. Those issues, I do think, go to a jury. The fugitive tolling provision, some courts have held, does not. And I think Wilson makes this a harder case than maybe it would be in other circuits, right? Because here you do have a tolling provision that was a tolling agreement that involved whether certain offenses were directly related to the period of time that the defendant had waived under the tolling agreement. So I think the district court's reading of Wilson was reasonable. On the other hand, I do think that many limitations issues under the WSLA can be resolved pre-trial.
So if we assume that a properly raised defense along these lines would have gone to the jury, why isn't there prejudice, Strickland prejudice, insofar as the defendant lost chance to have the jury decide that issue? And the district court itself told us that had the issue been properly teed up, he would have submitted it to the jury.
So I think, Your Honor, in that might be enough if the defendant's claim were simply that he wanted a chance to get this, or sorry, I think that might be enough, Your Honor, if the defendant's claim was these counts never should have gone to the jury, right, in the first place, because, sorry, let me take a step back here. I think that either way you look at it, really, the district court had to resolve the question it ultimately did in its reconsideration order, which was, regardless of the identity of the fact finder, the identity of the decider, is there a reasonable probability that that fact finder, that decider, would have resolved the question in his favor?
I didn't read the order that way. I'll take another look at it. But I read it as saying that if the district court were the appropriate fact finder, he would resolve the limitations issue in your favor. That's different from saying that no reasonable jury, if given the chance, could have resolved it in the defendant's favor.
I think that's right, but I don't think the no reasonable jury standard is the right one under Strickland. I think you'd have to say, is there a reasonable probability
reasonable likelihood? There's a
Yes.
reasonable likelihood that the defense would have prevailed, and we don't know. All we know on that question is what the district court said in the first order, which is that there's enough evidence on both sides to send that to the jury.
Right, and I think there, Your Honor, we made this comparison in our brief, in footnote 13 of our brief on page 51. I would compare it to the Nuoye case from this court, where the question was whether it was ineffective assistance counsel involving a duress defense, whether defense counsel should have put on expert testimony regarding battered woman syndrome to justify essentially an instruction on duress. And this court made very clear in that scenario, it wasn't just enough to say, okay, the first step is, should you have put this on to get the instruction? You also have to show in the Strickland posture a reasonable probability that once you got to the jury, it would have resolved this in your favor. I think that to me is the right analogy here. You can't just say, could I have gotten to the jury on this? The question is, if I got there, have I shown a reasonable probability that the jury would have resolved this in my favor?
No, I agree with you on that. But in order to rule for the government here, we would have to find no reasonable probability that the jury would have resolved it for the defendant, correct?
That's correct. And I think, and again, that's on prong two, right? I think we've made an argument under prong one of the Strickland test, right? That counsel was not deficient given our construction of clause 3. And of course, the other arguments we've raised below and raised here about clauses 1 and clause 2. So we think we have arguments under both prong 1 of Strickland and prong 2, just to be clear, Your Honor. But I think, Your Honor, on the prejudice question, on the question of how the jury would have resolved this, I do think the best indication is the district court's view. The district court, which presided over this trial, heard the evidence, including defense counsel's reading the statement from Colonel Britton about the importance of Mr. Doost's mining operations to stability in post-war and post-combat operation in Afghanistan. The court heard that evidence, was the most familiar with it. And so while the court was, as Your Honor correctly pointed out, explaining how it would have resolved the case if it was the proper decider, I think that's the best metric for this court's review.
I don't understand Strickland to embrace that view at all. Okay, but let me ask you, what's your response to Appellant's argument about clause 2?
About the real property versus a movable property issue, that one, Your Honor? So I think that on the face of the statute, it was reasonable for defense counsel to read real or personal property as applying to money or funds. To take one step back, Your Honor.
Well, clearly the legislative history of that clause had nothing to do with moving money, all right? Congress had something else in mind. And I just want to understand how you move beyond that when Congress had and knew it had all these other provisions to get at money.
So 2 points, Your Honor. I think you are correct, and Mr. Doost is correct that the original version of Clause 2 referred solely to the certain property under the Surplus Property Act, which perhaps would have, lend itself to a reading that a personal property is movable property. And this is, I'll be honest, Your Honor, this is not in our brief, but if you actually look at the way the statute evolved, when Congress amended the statute in 1948 to make the WSLA permanent and not just a temporary wartime measure, it actually moved the clauses around and broadened the language of what is now Clause 2 to its current form. And so it does not have just a reference to the Surplus Property Act, that temporary act. It instead embraces what we think on its face is much broader language, real or personal property. And it has terms like custody or control that we think are often used to refer to money and funds. The bank fraud statute, for example, Your Honor, 18 USC 1344 talks about custody or control. I think no one disagrees that the bank fraud statute applies to money. So we've included some cases, Your Honor, including the 10th Circuit's decision in Delia, a North Carolina District Court case, and a Third Circuit case construing a federal embezzlement statute that all use language like personal property and read that to include funds. So again, because the court is looking at this through the lens of ineffective assistance of counsel and asking whether a reasonable lawyer, a competent lawyer looking at this case back in 2017 with a very limited body of case law could have concluded that Clause 2 reaches this and that he shouldn't raise the objection, I think the answer is yes. And that's the framework we think you should look at it. The court doesn't have to decide here. It doesn't have to authoritatively construe Clause 2 to find that counsel was not ineffective for taking the statute on its face, looking at dictionary definitions like the one in black, and adopting a plain language construction of Clause 2 that is supported, we think, by the case law that does exist on it.
Can I ask a different question about Clause 2 and how the three clauses relate? At the end of Clause 3, there is this language which is connected with or related to prosecution of the war. Does that clause modify just Clause 3 or all three clauses?
Yes, the government's position, Your Honor, is that it modifies only Clause 3. Some of that drafting history I just meant, I think, supports that. And I should be honest, Your Honor, the district court decision in Nishi out of Hawaii, cited by Mr. Doost, reached the opposite result. The government has appealed that decision, and it's being argued in the Ninth Circuit in January.
So, I mean, that reading seems perhaps grammatically more plausible, but it would produce some seemingly astounding results. I mean, you would have to say that take Clause 1, any offense involving fraud against the United States, you would have to say there's been no statute of limitations in False Claims Act Medicare claims since the AUMF. That's,
Your Honor,
pretty implausible.
Yes, well, a couple points. It is broad. I don't think it's perhaps as broad as Your Honor just suggested, because in the Kellogg, Brown, and Root case, the Supreme Court decided in 2015, it held that the WSLA applies only to criminal offenses and not civil offenses. So in terms of civil liability under the False Claims Act, that's not going to be a problem, I think, for defendants.
A criminal prosecution of a doctor for fraudulent billing of Medicare has no statute of limitations since the AUMF was enacted. That's your position.
Right. Yes, I mean, so the short answer is I haven't thought through that statute, but the government's position is that the directly connected to language at the end of Clause 3 applies only to Clause 3 under the last antecedent canon.
Assuming I disagree with that, then the Clause 2 issue raises the same issue we've been talking about in connection with Clause 3, which is this kind of development project related to prosecution of the war, which may be a fairly litigable issue.
Yes, I think if you rejected our view of the statute, then the language would apply across clauses 1 and 2, ostensibly, if the court adopted the niche view. I would say, of course, Your Honor, that hasn't been briefed here, and if the court is concerned about that in any way, then I think that that's all the more reason to look at this on prong 1, right? Could a reasonable lawyer back in 2017?
It just goes to that. That's the thought that I perhaps clumsily expressed at the beginning when I said I thought the clauses were similar. Just on, well, if the nub of the defendant's argument is that this case is not something connected to prosecution of the war, there's at least an argument that concern covers Clause 2 no less than Clause 3 when we're assessing the lawyer's competence.
Right, I'm not going to disagree with Your Honor on that, given the decision in Nishi and the pending appeal on the Ninth Circuit there. But I guess I would suggest that the defendant has conceded here, and of course the district court itself has applied a construction of Clause 1 that would reach the major frauds and wire fraud counts here without asking whether those are directly connected to the war.
Well, yeah, clause 1 is out of the case on different grounds on the
Right.
strong elements test, but
Right.
clause 2 may or may not be.
Right.
Okay.
Mr. Azam, just to be clear, the clause that you think applies only to starting with which is connected, you're saying applies only to clause 3. Does that also include the following clause or with any disposition of termination inventory? You're saying that whole thing applies only to clause 3?
Let me just look at the statute. Your Honor, give me one moment. I'm sorry.
Mhm.
The position.
I think grammatically, it would have to all apply only to clause 3 or all apply to clauses 1, 2, and 3.
You know, Your Honor, I haven't looked back candidly at the government's brief in the Nishi case to see how it handles that. And so with that appeal pending, I don't want to misspeak and misrepresent the government's position on that issue. I can certainly get the court a letter, or I can refer the court to the Nishi case, which is 19-10405. And again, I think because part of our argument there depends on the enactment history of the statute, I actually just don't recall, Your Honor, whether that piece of the statute was part of the original version or was added in the order I mentioned in the 1948 codification. If the court has no further questions, we would ask that the judgment below be affirmed.
Where we're talking about multiplicity in the false statement counts, and you're discussing Mangieri, but you're saying by analogy, this is quoting your brief, that makes the unit of prosecution in a section 2197N case such as this one, quote, the induced illegal transaction, not the made falsehood, end of quote. What does the phrase such as this one mean? In other words, the basic question is what is the limitation? And that seems to be the limitation you're suggesting. And I'm not sure I know what that means.
Your Honor, I think what, if I'm remembering correctly, Your Honor, I think I was just trying to capture the notion there, Your Honor, that Mangieri itself had announced kind of a general rule in the duplicity context for false statements under 1014, under 18 USC 1014, and then said it didn't foreclose the possibility that under some circumstances,
I know.
multiple.
Such as this one. All right. What I'm getting at is the district court followed the 10th Circuit, yet we have a series of cases where we looked at the language of the indictment. All right. And the district court really didn't discuss that in addressing the multiplicity argument. Rather, he looked to the terms of the loan. And you don't pick that up in your brief. And that's why I'm trying to understand, what does the government think is the limitation here?
I'm sorry, Your Honor, the limitation on
Multiplicity.
Right. So I think, Your Honor, our view is that this is a different case than Mangieri because each of the fraudulent representations, even though they were within the same disbursement request under the loan, triggered a payment in a different amount to a different payee in a different country.
Well,
so we think that
I want to be clear. That could mean every dollar, if in every $100 dispersed to different vendors. But I thought your reference on page 41 was trying to draw some way of limiting what was going on here. And I thought maybe it was a reference to the terms of the loan itself. I don't know. That's why I'm trying to understand.
Right. Yeah, no, I take your point, Your Honor. I would distinguish the two different multiplicity arguments. I do think on the first multiplicity argument regarding the major fraud counts, that the terms of the loan itself is very important. The district court itself focused on that, and the indictment did too. And I would point, Your Honor, to paragraph page 8 of the appellant's appendix, paragraph 4A. Mr. Doost highlights that.
I'm looking at the indictment. Starts on my copy, appendix 14. This is appellant's appendix.
Yes. So at page 14 of the version I'm looking at, Your Honor, it addresses the money laundering counts.
Yeah.
Which I think are not part of the, as I understood, is not part of the multiplicity challenge.
Right.
The multiplicity challenge concerns the counts above that.
False statements.
Exactly, Your Honor. That for me, that is, at least for me, that's on page. I guess that's on top of page 13.
On page 13.
Yes, exactly. And so
14 and 15.
Right. And so our view on those is, yes, they are within the same disbursement requests. And so under Mangieri, right, those could potentially under Mangieri, those could be properly included in a single count. Now, that would raise the question, right, of whether the defendant would be entitled to a specific unanimity instruction to ensure that this is obviously in the hypothetical world where this is in one count, to ensure that jurors unanimously agreed on which false statement they found Mr. Doost to have knowingly made.
In other words,
but we think
the underlying point of my question is, it seems to me that this circuit and the 10th Circuit have taken somewhat different approaches toward this question. And in Bruce, we cited cases that suggest that the way the 10th Circuit is viewing this is not the way we would view it. And I'm trying to understand, and I know the district court applied the 10th Circuit approach, is how this argument fits within our circuit's view. And of course, as you point out, everybody's arguing by analogy to a banking statute, but still.
Right. So I think, Your Honor, I tried to say this earlier, and I'm not sure if I was clear about it, but I wanted to distinguish between the false statements count that Your Honor is just looking at in the indictment there. That is a case where I think the court did apply Mangieri directly, right? In footnote 12 of Mangieri, the court, when it said, we're leaving open the possibility that in some cases, 2 false statements in a single document can be 2 counts, cited to a Fifth Circuit case. I think that
this round and round and round. My question is, what does the government mean when it says such as this one?
Right.
No, Mangieri left it open, but what is it?
I said,
yeah.
I think I was just trying to say, Your Honor, that just like this court in Mangieri, we're not suggesting that there is necessarily an across the board rule that multiple false statements in a single disbursement request can always be or can never be. That's what we understood Mangieri to say. We think the district court reasonably resolved that. I don't want to leave Your Honor confused about this. The 10th Circuit issue
is the argument of the government that where the loan itself calls for transactions that are discrete, that is not violative of the multiplicity approach. In other words, you know, in Bruce, we cited a case where somebody owed taxes over a 12-year period. So every year, you know, he didn't pay his taxes. We said, well, that's just a course of conduct. So the argument here is that he took out this loan and he didn't pay it back.
Right. So I think that is an area, Your Honor, where I think the district court did follow Bruce. Yes, it looked to the 10th Circuit as I think a helpful summary of what kind of factors the courts have looked at in the bank fraud context, analogizing to major frauds cases. But what did Bruce say? Bruce said, like you said, Your Honor, look at the indictment. And I was trying to point, Your Honor, to a couple pages ahead of where you were looking, because I think a couple pages ahead of there, you'll look, and this is on page, for me, this is page 8 of the appendix, under manner and means of the scheme and artifice. Right. It's paragraph 4A, where it says, Doost and others would obtain a $15.8 million loan from OPIC. That's a single loan, right? For development and maintenance of the marble mine. Thereafter, Doost and others would submit requests for disbursement of loan funds to cover alleged reimbursable costs of the marble mine. So I think the way the indictment describes the scheme is not as this single act of fraud in the inducement. It's continued fraud, not just the course of conduct.
Bruce was concerned about notice to the defendant. That's why I'm on page 13, as opposed to this general statement, which could simply be, this was a single transaction, a single loan from OPIC.
Right. And I think, Your Honor, before we get to page 13, on page 10, the box at the top sets forth these counts, right, in enumerated counts 1, 2, and 3, different dates, different amounts of money. And right above that says, to wit, Doost and his consultant submitted to OPIC via email or in person 3 disbursement requests. So I think if you look at the way the indictment is structured, both in the allegations and in the actual enumeration of counts, and of course, other factors the district court considered, right, that Mr. Doost is signing a new promissory note for each disbursement request. He has therefore has a new and different obligation to be truthful. And to take one step back, Your Honor, I think this is quite different than a case. You can imagine a case in which Mr. Doost lied to OPIC in his loan application and said, he misrepresented the collateral or his ability to raise matching capital contributions, which was a condition of the loan. But then when it came time to submit the reimbursement requests, he was scrupulously honest. In April, July, December, scrupulously honest. That would be a 1-count case because he had other occasions to be dishonest. The actual financial risk and flow of money out of OPIC's coffers occurred in 3 different stages. Multiplicity is, I think, in these scheme cases, very fact specific. We think the district court correctly applied kind of consensus principles from Bruce and other circuits' law. And again, because we're looking at this through the lens of ineffective assistance of counsel, you also have to ask, was counsel unreasonable, objectively unreasonable? Would no competent lawyer have think this claim would have failed? That's the test from Primo versus Moore.
Anything further, my colleagues?
No, thank you.
Thank you, counsel.
Thank you.
Counsel for appellant, we'll give you 2 minutes.
Thank you. Thank you very much. So quickly, I would just like to point the court to what I believe the correct standard of prejudice to apply in this case out of the Mohammad case, US v. Mohammad. And that is, in assessing the prejudice, the ultimate question is whether the defendant has shown a reasonable probability that an adequate investigation, in this case, it was case law and bringing to the attention the time-barred charges, could have enabled trial counsel to sow sufficient doubt to sway one juror. So it's not collectively what a jury would have done. It's does the evidence sway one juror? And I think that's
Mr. Schwartz, your brief on the timeliness point focuses primarily on the prejudice prong, but can you speak to the deficient performance, to the first prong of Strickland with respect to timeliness?
Just timeliness? Timeliness? I think I talked about it a little bit in Abney. Looking at a statute that has reasonable interpretations going either way, and failing to raise that statute, that would fall underneath the Abney case, which of course found deficient performance. And I think the exact wording in that case was the failure to act on a reasonable probability and probable interpretation of a statute that could benefit the client. Again, and Mohammed expands on that and says, only when such a reasonable investigation, in this case, case law research at all, you have to inform yourself in order to make a strategic decision. So that again goes to the deficient performance. And I think the U.S. Supreme Court talked about it in versus Alabama, 571 U.S. 274. And that's an attorney's ignorance on a point of law, which is fundamental to his case, combined with failure to perform basic research. But that's actually the exact wording in that case, is the unreasonable performance under Strickland. And I guess very quickly, I'll touch on the multiplicity issues. which I guess are prevalent in both the false statement and obviously the major fraud counts. The Bruce case was obviously correctly stated, and I believe that's the binding case here. There was a single scheme to defraud. It was the same victim, the same bank, and the same methods were used. And that's exactly what has happened in this case. And, we talked about the 10th Circuit briefly. The Reitmeyer case, I think, is also controlling, even though they have a differing standard. What happened in that case is there was a claim for false payment initially made, and then there was a subsequent meeting where they made the same misrepresentations to garner the same amount of funds. So the financial risk was not new, and there wasn't a separate set of funds. And that's exactly what happened here. The loan was approved, and there were the alleged shell companies in this case had been created prior to the approval of the loan in our case. And he had alleged to have already received loans from other government agencies to fund the same equipment that he got from the OPIC loan. So, the scheme was when the loan funds were approved. That is when the funds could no longer be used for any other loan applicant. And this circuit holds that is when it is executed. And the disbursement requests were plainly just in furtherance of the scheme. So with that, I would ask the court to dismiss the time-barred counts, dismiss the multiplicitous counts, and award a new trial based on ineffective assistance of counsel. Thank you very much.
Thank you. We'll take the case under advisement.
Case number 19-7074, Derwin Patten et al., Appellants versus District of Columbia. Mr. Ruffin for the Appellants, Mr. Schifferle for the Appellate.
Good morning, counsel for Appellants.
Good morning, Your Honors. I'm Thomas Ruffin. If it please the court, I'm Thomas Ruffin. I'm the lawyer for the Appellants, Hazel Brooks, Derwin Patten, and his brother Roy Patten. In our view, the fundamental issues in this case can be stated more or less in twofold, and I think it looks at it in this way. Does the Randolph-Shepard vending facility program mean that when a blind person joins that program, that those blind people lose all of their rights under the Americans with Disabilities Act, the Rehabilitation Act, and the Human Rights Act, and any other anti-discrimination statutes? Because as the district court held, any factual allegation of discrimination must be regarded as a complaint about the operation and the administration of the Randolph-Shepard program. And then coupled with that, and that includes the proper reading of the fact allegations as to whether they allege violations of the Americans with Disabilities Act, the Rehabilitation Act, and the District of Columbia's Human Rights Act. But coupled with that statement of one issue, you would also look at whether the DC Code at section 2-1831.03, that is, as part of the Office of Administrative Hearings Establishment Act of 2001, says nothing about, since that statute says nothing about jurisdiction of the Randolph-Shepard program cases, and since the dictum in an Office of Administrative Hearings case titled M.F. through G versus Department on Disability Services, Rehabilitation Services Administration, never mentioned mayoral action coupled with the Office of Administrative Hearings Chief Judge action so as to enlarge OAH, Office of Administrative Hearings jurisdiction, to hear Randolph-Shepard cases. Under those circumstances, does the Office of Administrative Hearings have jurisdiction to hear a Randolph-Shepard blind vendor case? And when we look at this, we say that the Office of Administrative Hearings has no jurisdiction to hear these cases, and that the reading of the Randolph-Shepard Act by the U.S. District Court is overbroad insofar as it basically says that any allegation of illegal discrimination must be read as asserting rights under the Randolph-Shepard Act.
Mr. Ruffin, so at least as I read it, it seems our circuit precedent requires us to read the Randolph-Shepard Act as providing for mandatory exhaustion of administrative remedies. Do you agree with that reading of circuit precedent?
Not in all cases. I think it calls for that when a Randolph-Shepard blind vendor asserts rights under the Randolph-Shepard Act. So like, for example, if you look at the case of Committee of Blind Vendors versus District of Columbia, the blind vendors associations that filed that lawsuit, they actually alleged problems with the application of the Randolph-Shepard Act. And they said that the state licensing agency was not properly administering the program. And then similarly, if you look at the Weinberger case, there was the issue of whether two different fast food chains could set up fast food restaurants in the military bases. And the Randolph-Shepard blind vendors said that, hold it, that violates our rights under the Randolph-Shepard Act. And so I think when, in answer to your question, Your Honor, when Randolph-Shepard blind vendors assert their rights under that Randolph-Shepard Act or allege problems with the actual administration of the program as a program itself, then there would be a requirement of exhaustion. However, I think even with that, there's a question about exhaustion that needs to be explored more deeply than what has been done historically.
Do you think, though, I mean, so I think part of your claim is futility, right? That the OAH lacks jurisdiction, and so it would be futile to raise those claims before the OAH.
Yes, ma'am. Yes,
and so I guess one of my questions is, after the Supreme Court's decision in Ross v. Blake, are we permitted to read a futility exception into a mandatory exhaustion scheme like the Randolph-Shepard Act? And is there anything in the Randolph-Shepard Act that suggests we can apply judge-made exhaustion exceptions to the exhaustion requirement?
Well, I think that this court would probably be reluctant to apply judge-made exceptions to the exhaustion requirement. However, even when we're looking at the exhaustion requirement, let's say that that absolutely applies. We have to look at the scheme that's been set up by the state licensing agency, and that's the District of Columbia government. The Council of the District of Columbia set up in section 2-1403.03 subsection B a fair hearing process that's required under the Randolph-Shepard Act. And it set it up specifically for civil rights cases. But when you look at Title 20 of the United States Code, sections 107D-1, subsection A, and 107B, subsection C, the Randolph-Shepard Act calls for a fair hearing for the blind vendors. It didn't say set it up at the Office of Administrative Hearings. It didn't even say set up an administrative hearing. What it said is give the Randolph-Shepard blind vendors a fair hearing. And the council very carefully crafted for all civil rights claims in section 2-1403.03 subsection B of the DC Code, the option of anybody, the Randolph-Shepard vendors going to court, any court of competent jurisdiction, or to the Office of Human Rights. And in fact, under the District of Columbia regulations, Title 4 of the DC Municipal Regulations at section 128.1, if the Randolph-Shepard blind vendors took their matter to the Office of Administrative Hearings, as the government has insisted, the Office of Administrative Hearings would be required to tell my clients and any other blind vendor, take your case to the Office of Human Rights under the DC Code section 2-1403.03 subsection B. and make it clear that the Office of Administrative Hearings would have no jurisdiction to hear a discrimination case. And so what we really have here is the government on the one hand in its advocacy and the district court in its opinion below, looking at the allegations, the fact allegations in the Second Amendment complaint. And even though they're talking about traditional claims under traditional disability discrimination claims under the ADA and under the Rehabilitation Act, they're saying, well, since it's in the Randolph-Shepard program, you're really talking about how the Randolph-Shepard program deals with these matters, and that must be exhausted. Okay, if it does, then it has to be exhausted as the city provides for it. The legislature provides for it at section 2-1403.03 subsection B. And I think that's something that the government just, for one reason or another, has not squarely responded to. And that's just a real problem. And then we have, on top of that, the Office of Administrative Hearings, Establishment Act of 2001. And that's at DC Code section 2-1831.03. There is no reference at all to the Randolph-Shepard program in that jurisdictional statute. However, there is one reference in that statute to the Office of Administrative Hearings taking jurisdiction over cases from the Department on Disability Services. But it's not from the Rehabilitation Services Administration, which holds the Randolph-Shepard program. It's rather from the Developmental Disability Administration. And that's under section 7 dash, pardon me, that's in section 2-1831.03 subsection B15. And that refers to severely disabled individuals, developmentally disabled individuals pursuing actions under section 7-761.13. And that is totally different from what's set up in the Randolph-Shepard program. That's number one. And the government in another case, in a related case that was at the DC Court of Appeals, agreed with us that that section does not apply to the Randolph-Shepard program. However, even there, that matter that deals with the one point where the legislature said, okay, the Office of Administrative Hearings has jurisdiction over something from the Department on Disability Services. That case has to go first to something called an external reviewer and then appeal from there to the Office of Administrative Hearings. And even then, under section 7-761.13 subsection C, and also under 29 District of Columbia Municipal Regulations, section 13,206.1, they make clear that those disabled individuals' civil rights are perfectly preserved, even though they may exhaust remedies for administrative issues through that process. And I add that because I'm sorry, yes, ma'am. I'm sorry.
You've exhausted your time. Let's hear from the government, and then we'll give you a couple of minutes on rebuttal.
Thank you very much, Your Honor.
Good morning. May it please the court, Carl Schifferle for the District of Columbia. It is well established under this circuit's precedent that the Randolph-Shepard Act mandates exhaustion of administrative remedies prior to judicial review. That exhaustion requirement applies broadly to, quote, any blind licensee dissatisfied with any action arising from the operation or administration of the vending facility program. The district court was correct that plaintiffs' claims involving access to program documents and inspections of their facilities by program monitors arise from the operation of the program. They are indeed challenges to the administration of the program and thus must be exhausted. Alternatively, plaintiff's complaint fails to state a plausible claim of disability discrimination And the district court found as much. The plaintiff's brief does not address that ruling in its plaintiff's brief. Opening brief does not address that ruling, and thus it would be forfeited in any event. I can address first the exhaustion point. The plaintiffs pursued two types of claims on appeal. The first involves access to program documents in a format that they can read. These claims arise directly from the administration of the program. The statute and the implementing regulations generally entitle the plaintiffs to access to these documents. Those regulations also provide for auxiliary services such as communications in Braille or audio recordings. And they more generally provide, for vocational rehabilitation services, and those would include auxiliary aids of the type the plaintiffs are seeking. The second type of claim that plaintiffs pursue on appeal involves the inspection of their facilities by program monitors. They challenge the nature or even just the fact of the inspections, as well as the qualifications of the program monitors conducting the inspections. But once again, this is something that arises from the administration of the program. The Act requires the Rehabilitation Services Administration as the state licensing agency to manage and supervise each facility in the program. And the regulations require that where that facility is not operating in compliance with its operating agreement or with applicable laws and regulations, that the Rehabilitation Services Agency administration has to revoke that operating license. Plaintiffs can't simply evade this analysis that shows that their complaints, their grievances arise from the operation of the operation or administration of the program simply by labeling the claims as disability discrimination. I mean, I would first point out that there will still ultimately be judicial review. So it's not as though, as Mr. Ruffin suggested, that these claims will not ultimately be heard by a federal court. It's simply a question of exhaustion of administrative remedies. And the plaintiffs can't avoid that requirement, as I said, by simply labeling their claims as disability discrimination. One of the reasons why this court has required in Committee on Blind Vendors for exhaustion is that the need to prevent circumvention of the prescribed administrative process. And that circumvention would be, that risk would be particularly acute here, where this program is only open to individuals of plaintiffs who have plaintiff's type of disability. So it would be the case that any vendor in the position of the plaintiffs could simply label their grievance with the operation or administration of the program as a claim of disability discrimination. And there's also the risk as well, not only circumvention of that administrative process, but parallel proceedings where you have both an action in district court and then parallel proceedings in the administrative process. And that's another reason why exhaustion exists, to avoid that possibility.
Mr. Schifferle, has OAH previously exercised jurisdiction over similar types of discrimination claims? Are there examples of that occurring?
The OAH, assuming that the OAH does not have the authority to adjudicate directly claims of discrimination, and so I'm accepting the premise of Your Honor's point. That may be true, but that doesn't obviate the need to exhaust. The Office of Administrative Hearings regularly hears cases involving the Randolph-Shepard Act. There's no question that there is an administrative process available to hear these grievances. And that administrative process serves benefits, even if the Office of Administrative Hearings can't directly adjudicate the claim of discrimination. It nonetheless can create an administrative record, can conduct fact-finding. And
does it regularly, or does it occasionally do that in cases that raise discrimination claims?
Well, I would point to Mr. Patten's own proceeding before the Office of Administrative Hearings, where he challenged the termination of his operating agreement for the facility at the Defense Intelligence Agency. That decision is in the record in the appendix in this case. And that's the way the process should work, that the claims of discrimination, disability discrimination can be raised in the context of the administrative proceeding, but the administrative proceeding can still take place. You can still have a determination by the Office of Administrative Hearings. That then can go to the Secretary of Education to convene the arbitration panel, and then ultimately to a federal court on review. So just as the situation in numerous cases in this circuit and the Supreme Court, or even if, for example, a statutory claim or a constitutional claim couldn't necessarily be adjudicated by the administrative agency, nonetheless, that did not excuse the exhaustion requirement. And I'm referring specifically to cases in the Supreme Court, like the Elgin case, cases in this court, like AFG versus Trump, decided in 2019. Those cases likewise presented situations where, for example, constitutional challenges to the validity of other statutes, and even assuming that the administrative agency where the plaintiffs had to go to exhaust couldn't adjudicate those types of claims. Nonetheless, the court held that exhaustion was required.
How can a blind vendor claim disability discrimination on your theory if I'm surprised to hear you say that the agency can't adjudicate that claim? How do they ever get it litigated? They can't raise it before the agency, and then the only thing that's subject to judicial review is the Randall-Shepard determination, which you've just said doesn't encompass a question whether the vendor was discriminated against.
No, the ultimate judicial review would encompass a claim of disability discrimination.
Judicial review in a court of appeals of the agency action, which is the arbitration. And there's a channeling mechanism. You start with, you have the state agency making a finding, and that's reviewed in a federal arbitration, and that's reviewed in a court of appeals under the APA.
Or, well, my understanding would be reviewed in the district court under the Randolph.
I'm sorry, district, but under the APA, under the standards of.
Right, and that would be correct. I don't think that would be any different than the Elgin case, the Supreme Court case, where it was under the Civil Service Reform Act. The Merit Systems Protection Board would be issuing the adjudication that will be reviewed under the APA by a federal court. Likewise, in AFG versus Trump, a decision of the Federal Labor Relations Authority, again, reviewed under the Administrative Procedure Act, same sort of judicial mechanism of review.
Right, but your theory now is that Randall-Shepard, not only does it provide the exclusive channeling mechanism for raising claims, which is start with the state agency and proceed as we discussed, but it actually, as a substantive matter, impliedly repeals the ADA and the Rehab Act.
Not at all, Your Honor. I mean, just because it channels those claims through an administrative process doesn't mean it repeals those acts, because, as I said, ultimately there will be judicial review. Maybe an example might help clarify. There could be a claim that my operating agreement was improperly terminated, and it's based on discrimination. Mm-hmm. The reason for the termination ostensibly is the facility was not kept clean. The vendor could argue, well, that wasn't the standard to apply, and in any event, I kept my facility spotless, and therefore it was pretext for discrimination. The administrative agency can still proceed to resolve issues related to that claim, what in fact the program standard was regarding cleanliness, whether as a factual matter the facility was kept cleanly or not. And ultimately, as I said, the purpose of exhaustion is, even if the administrative agency can't necessarily finally adjudicate those claims, it can facilitate judicial review by creating that record, by creating fact-finding that a court will ultimately review and pass upon the merits of any claim that plaintiff has. We believe that's consistent, as I said, with the case law from the Supreme Court and from this circuit in terms of how that administrative process works when you have, for example, constitutional claims or other statutory claims that the agency may not be able to necessarily fully adjudicate. Nonetheless, exhaustion is required in those circumstances.
So is that true even where the remedy under the federal discrimination statute would be different? The available remedy?
Yes, as long as there's meaningful judicial review. I don't think it requires that every particular aspect of remedial relief be necessarily available through the administrative process. But as long as there's meaningful judicial review.
But meaningful judicial review is limited by the Administrative Procedure Act. My hypothetical is if you were a plaintiff in the district court proceeding on a complaint under the discrimination statutes, you'd still have your burden, et cetera, but the APA would not be involved.
I think it would. If I understand correctly, I mean, these cases, once they go through the administrative process,
No. I'm following up as to whether or not the way you're interpreting the mandatory requirement means that, I mean, I could come up with a hypothetical that any other plaintiff who's not blind or otherwise covered by the Randolph-Shepard Act could go to district court, claim discrimination under these federal discrimination statutes, and end up, one of the remedies is a brand new car.
Or money damages.
Or money damages, much less attorney's fees. Whereas you cannot get that through the Randolph-Shepard Act.
Well, as I said, I mean, it's my understanding.
That's what I'm getting at.
Right. It's my understanding, first of all, that the availability of the same type of relief isn't a necessary prerequisite to an exhaustion requirement. Secondly, there's no reason for that I know of that the district court couldn't award appropriate relief upon review of the final administrative decision in Randolph-Shepard Act cases.
A new car, I mean, I tried to make it extreme. I mean, obviously money damages is different. In other words, I understand the channeling notion, and I understand in the Civil Service Reform Act context, the remedy doesn't necessarily have to be the same. But there's no question here that under the mandatory exhaustion requirement, not only do you have to spend a lot of time and money going through that process, you can't get your car. Whereas if you were a non-blind person, you could file your complaint in the district court, and if you were able to meet your burden, then the district court would be able to award you this car. I just want to make an extreme situation. Not only, I mean, the theory was this was going to be a less expensive, timely process for the vendors to get what they are complaining about. If they want these aids, if they want the documents in readable type.
And yes, and that benefit of the process is served. It may well be as a result of the administrative adjudication that those issues are resolved. It's an opportunity for the agency to correct any errors. If access to program documents needs to be fixed.
So is this an application of implicit repeal?
No, Your Honor, I'm not suggesting that at all. And in fact, as I said, I think the district court on review would have the opportunity to award appropriate relief. I'm not.
Just to put it, an attorney's fees?
I think that district court would, if it's necessary in order for exhaustion to be a requirement, then I think the district court would have the ability to award appropriate relief after that administrative process is exhausted. As I said, it serves a purpose in allowing the agency to correct errors, to develop a factual record.
That's the issue that we're getting at, all right?
Let me try, if you're done, Judge Rogers.
Yeah, please.
Let me try it this way. Trying to exploit the fact that review starts in district court. So the plaintiff goes through the mandatory exhaustion, and based on what you've said here, the plaintiff can litigate all of those issues in Randall-Shepard terms about, was the vendor fired for violation of the operating agreement? And that will generate, that process will generate whatever fact finding it generates, expertise is brought to bear, and so on. Goes up through the secretary, and then at the end of the administrative process, the aggrieved vendor files a complaint in district court. And the complaint has two counts. Count one, through the APA, seeking judicial review of the Randall-Shepard determination. Count two, under the ADA, seeking a de novo trial of the disability discrimination question, seeking money damages, and let's assume that the administrative findings have whatever preclusive effect they have, but to the extent that the agency hasn't directly addressed disability determination, plaintiff says, I want a trial on those open issues. Is that count two litigable on your theory at that point?
I think it may well be. My argument certainly is not premised that it would not be litigable. I mean, Your Honor mentioned the preclusive effect of factual findings, so I would at least insist upon that.
Which might narrow the case, but on your representation that the agency won't directly be deciding the question of disability-based discrimination, it wouldn't end the case. I mean, suppose the agency says, well, you breached your operating agreement and that's basis for termination under Randall-Shepard. It would still be open to the plaintiff to say, well, yes, but a similarly situated non-blind person wouldn't have lost the contract.
Yeah, it might not necessarily do so, but the plaintiff could be satisfied with the outcome of having their operating agreement restored. So there's certainly many possibilities in which judicial review would not be necessary ultimately. I would also, given the questions on exhaustion, I would want to make the point too about the district court's ruling that the complaint in itself failed to state a plausible claim of disability discrimination. The district court, I think, was quite correct to say that the allegations merely suggested that the reason for the actions was the plaintiff's participation in the program. It was not by reason of disability, it was by reason they were vendors in the program. As I said, this issue was forfeited by the plaintiffs by not challenging that particular aspect of the district court's ruling. In any event, that district court ruling is correct. We believe that this program, again, is only open to those with plaintiff's particular type of disability. And so it's not a question of program monitors going out and inspecting others who are not participants in the program, for example. The inspections are clearly by reason of participation in the program. It just so happens the program is only open to those with plaintiff's disability, that particular type of disability. But that doesn't make it a plausible claim of disability discrimination. So I think even if the court has some concerns about exhaustion, that alternative base is also proper for affirmance as well. I do see that I'm out of time. I'm happy to address any questions from the court then.
Covered mine. Thank you.
Thank you.
Thank you.
Counsel for appellant?
Ma'am, Your Honor. I'll try to use my time as quickly, as wisely as possible. I want to say, first of all, that I think the court made a very astute observation. What the government is arguing and what would happen with the affirmance of the lower court opinion would be that for Randolph-Shepard blind vendors, those blind people, their ADA rights would be basically abolished. They would have no opportunity for injunctive relief at the Office of Administrative Hearings, no opportunity for damages. Office of Administrative Hearings insists that they have no authority to issue damages, to award damages, no opportunity for attorney's fees, and hence the blind vendors would have no rights under the ADA. I would even bring to your attention another matter with regard to the appeal of the matter under the Administrative Procedures Act. Under the DC code, under the DC regulations, if I'm not mistaken, the appeal would go to the DC Court of Appeal. It wouldn't go to a US District Court or to the Superior Court. And the DC Court of Appeals would have a very, very limited standard of review to apply. And it would basically be whether the law regarding Randolph-Shepard was properly applied, yes or no. Not whether my clients or any other blind vendors had rights that should have been protected under federal law or under the Human Rights Act. I will even mention again what the government consistently overlooks. Title IV, the District of Columbia Municipal Regulations at section 128.1 made sense of what was happening in my two clients' case, Hazel Brooks and Derwin Patten's case. When we raised the issue of disability discrimination affecting their performance in the Randolph-Shepard program, the Office of Administrative Hearings refused to take jurisdiction. And that section 128.1 of Title IV, the DC Municipal Regulations, says that any discrimination matter brought to any agency other than the Office of Human Rights must be referred to the Office of Human Rights. That applies to the Office of Administrative Hearings. And I think, notwithstanding what the lower court said and what the government says, my client's case is in many respects similar to what was litigated in Barnett versus DC Court of Appeals. My clients received written documents. My clients received written documents and they could not, pardon me, oh, this is beautiful. My clients received written documents and they could not possibly see or read the paper. And they asked for auxiliary aids and they weren't providing any. And moreover, if at a blind graduate of law school was taking the bar examination without any auxiliary aids, if that blind graduate had turned in their bar exam, however they took it, being unable to see the document, if their test was corrected by the National Conference of Bar Examiners and by local judges, while cited applicants, cited law school graduates had their tests corrected solely by the National Conference of Bar Examiners, those circumstances would be illegal segregation under ADA and the Rehabilitation Act. And all we're saying is that notwithstanding how the government examines our claims, we talk about not receiving any important communications, even unimportant communications in any form other than small print writing that blind people can't see or read. And that they were forced upon, that they had to endure inspections that were illegal under section 7-731, subsection A, paragraph 5, and subsection B of the DC Code.
All right, thank you, Mr. Ruffin. I think we have your argument. Or did my colleague have a question? We will take the case under advisement.
Thank you so much, Your Honors. Y'all have a beautiful day.
Case number 20-5074. Gerald H. Hawkins, individually and as a trustee of the C.N. Hawkins Trust, and Gerald H. Hawkins and Carol H. Hawkins Trust et al., Appellants, versus David Longley Bernhardt, Secretary of the Interior et al. Mr. Dearson for the Appellants, Mr. Smeltzer for the Appellates.
Good morning, counsel. Counsel for Appellants, please proceed.
Good morning. Thank you very much. I am David Dearson for the plaintiff appellants. I'd like to reserve, if possible, 2 minutes for rebuttal. Thank you. The district court dismissed this case on standing grounds, so it did not reach the government's motions to dismiss for failure to state a claim. We are asking both that this court reverse the dismissal as to standing and also to rule that the government's 12B6 motions should be denied as well. I want to begin by clarifying that the ranchers understand their rights are junior to the tribe's rights and that they don't seek to diminish or take the tribe's rights. Rather, they're seeking to vindicate certain important procedural principles, procedural rights which ensure that when the government exercises its power, and especially when it exercises its power in a manner that has significant impacts on the environment, that it bears some modicum of political accountability and that the proper decision maker be in place to make those final decisions. For us to establish standing on a procedural injury claim like this, all that needs to be shown is that if the procedural error were corrected, then the government might reach a different decision, one that could alleviate the harms done to the appellants. The United States filed these water rights claims. It litigated the claims in the Klamath Basin adjudication, and it lends its requisite concurrence to calls placed on the water to effectuate the claims.
Do you want to discuss redressability?
Sure, Your Honor. The redressability here, as we see it, is that, if these procedural errors are corrected, then someone in the government is taking a hard look at the serious environmental harms that are being done to the ranchers. And their injuries.
My point is that what about, and I gather you don't deny, that the tribe could continue to make a full call?
Yes, Your Honor. The tribes could continue to make calls. But, where the rubber meets the road here is that the Oregon Water Resources Department, they're the ones who issue these shutoffs that lead to plaintiffs' undisputed injuries. And as a matter of fact, and as a matter of Oregon state law, they don't effectuate those claims without having some concurrence from the United States government. And you can see that in the emails from the Oregon Water Resources Department that are pages 62 and 63 of the appendix, of which the district court took judicial notice, but did not mention in its opinion.
So your claim requires us to agree that under Oregon law, there is a concurrence requirement?
Well, I don't think it requires that, Your Honor, because I think the alternative grounds to rule in our favor is that the United States' position as manager of the trust assets, and the Department of Interior's and BIA's position as the entities with which Congress has charged the management of Indian affairs also places them in the final decision-making role.
So, Mr. Dearson, I think that is a question in which I'm quite interested. I mean, I think a lot of whether there is causation and traceability here depends on the nature of the trust relationship between the government and the tribes. And so I guess I want to understand, I think, so the Restoration Act, right, when it restores that relationship, what type of trust relationship was established by the Restoration Act? The government says it was a limited trust. The ranchers suggest it's something more than that. What is the evidence from the statute that there was a broader trust relationship created between the government and the tribes? And I guess what evidence is there? And then what is the content of that trust relationship?
Thanks, Your Honor. The government does point to cases like the Mitchell case from the U.S. Supreme Court that it's a limited trust. When you look at the decisions discussing limited trusts, the manner in which they are limited is that they don't limit the authority of the trustee. Rather, they in some cases limit, the ability of the trust beneficiary to enforce certain things against the trustee. And the cases that we have, cases discussing both the trust relationship generally, cases like the White Mountain Apache case, the Shoshone-Bannock case, and the Mitchell cases itself, suggest that the tribes cannot, force the government to take some action unless Congress has empowered them to do so. The opposite is the case. It's the government that manages these trust assets. And specifically with regard to NEPA, we cite several cases in our reply brief at page 27, such as the Stand Up for California case, the Impson case, and the Many Goats case, in which the 10th Circuit says, the duties and responsibilities of the secretary may conflict with the interests of the tribes, but the secretary must act in accord with the obligation imposed by NEPA.
But so what is, though, you said the government has to manage the trust assets, right? But you agree that the tribes are the beneficial owners of those water rights. So what is the government's obligation with respect to managing those water rights?
The government has several obligations and they may conflict. And so there may be a balancing necessary. For example, the very Klamath Treaty from which these water rights derive also has as an essential purpose the promotion of agriculture. And it's not necessarily the case in every instance that, merely because the tribes have been granted a ceiling on the water rights to satisfy their fishing interests. It's not necessarily the case that those rights have to be exercised to the fullest extent in every instance. And it's quite plausible that doing so, taking the full level of in-stream flow in every instance, frustrates one of the essential purposes of the Klamath Treaty, which is to promote agriculture. And I'd also point you to the memos from the Office of Legal Counsel that we cite in our briefs, which suggests that where there are such competing considerations, including considerations of the interests of Indian tribes and of citizens generally, and environmental interests, as Congress has charged the government with taking care of with NEPA, that the government has to arrive at a unified position. And so some balancing may be necessary in order to effectuate the dual purposes of the Klamath Treaty Act.
Well, I guess the question is, and I thought this is what Judge Rao was getting at, is if hypothetically we were dealing with the state of Arizona that wanted to put dams up so that the flow of water to your clients would be adversely affected. The tribes are a sovereign nation here in that sense as to its water rights under the treaty. Where does the Restoration Act give the United States any authority to balance, as it were, Arizona's interest in its own agriculture versus your client's interest, other than through the political process?
Well, the nature of the trust relationship doesn't really derive, I don't think, from the Restoration Act, but rather from the Klamath Treaty itself. And that is, that's the,
so you're saying there's a qualification in the treaty to the tribe's Aboriginal rights? I mean, the treaty was very specific as to what was reserved and what was not.
Well, I think that's right. I think it reserved hunting and fishing rights, and it also was designed to promote agriculture. And it's plausible that the tribes could take less than the full in-stream flows awarded to them and still have enough water to preserve their fishing rights while also preserving the possibility of sustainable agriculture in the Upper Klamath Basin community generally. And the Bureau of Indian Affairs.
It's conceivable, but the question is, where does the right arise in the United States, as you're arguing, to limit what the treaty otherwise preserves?
The United States, as trustee, as manager of the trust assets, is the entity that makes important management decisions about the trust. And I'll point you again to the cases at page 27 of our reply brief. It's not unusual for the Bureau of Indian Affairs to perform NEPA analyses before it makes decisions.
Oh, sure. But I guess that's why I asked you, and I gather you acknowledge that there is no concurrence obligation that affects the tribe under state law. And so you're relying on the treaty and the treaty's promotion of agriculture.
Your Honor, I'm sorry if I wasn't clear. I'm speaking about the treaty because I took that to be the substance of Judge Rao's question about the nature of the federal Indian trust relationship. But no, actually, very importantly here, there is the requirement in Oregon that as a matter of fact, and to the extent that the question is a factual question, I think we're entitled to a presumption in our favor on that issue in this stage of litigation. As a matter of fact, the Oregon Water Resources Department does not issue these shutoffs unless they've gotten concurrence from the BIA. And in those emails at page 62 and 63 of the appendix, the department does not even take the tribe's word that BIA has concurred. The tribes write in and say, here's our proposal for a call. We've got BIA concurrence. And
so you're saying that a concurrence requirement has grown up by pattern and practice over time?
No, Your Honor, I think those emails reveal the practice, but I also think that as a matter of Oregon state administrative law, to which the administration of these water rights are subject because of the Mccarran Amendment, cases like the Fort Vanoy case that we cite, or the Klamath Irrigation District case, suggest that as a matter of law in Oregon, it has to be the legal owner who goes to the Water Resources Department and effectuates these calls. So it is both as a matter of fact and a matter of law. The shutoffs just don't happen unless BIA concurs.
So both the Mccarran Amendment and the Restoration Act indicate neither is affecting the tribe's rights under the treaty. Is that correct?
I'm not sure I understand your question, especially as it relates
very
to
simple.
the Amendment.
What don't you understand about it?
Well, so the Mccarran Amendment subjects the administration of the water rights to state law. That's the ruling of the United States Supreme Court in the Colorado River case.
Right. It says the United States can be joined as a party.
Yeah, so the text of the Mccarran Amendment may not be completely clear on this matter, but the United States has decided in its Colorado River case that the effect of the Mccarran Amendment is to subject the administration of these federal water rights to a state administrative law. And I'd also point out that in the Adair case in the Ninth Circuit, in which the substance of these water rights was decided, they commended the district court for leaving that sort of administrative procedure to the state administrative apparatus.
So, Mr. Dearson, is your argument about the protocol then that the protocol is a problem because the government is delegating not only its ability to concur, but also whatever other discretionary fiduciary obligations it has over these reserved water rights?
Right. I think that both, the non-delegation doctrine says that, Congress charged the Department of Interior and the Bureau of Indian Affairs with the management of these trust assets, and it didn't authorize them to subdelegate that federal authority beyond the boundaries of those departments. Furthermore, Congress passed NEPA, which said that when executive agencies are making decisions that have such deleterious effects on the human environment, and here there's a state of environmental crisis in the Upper Klamath Basin community, that it has to, at the very least, take those considerations into account. At no point in this process, from the filing of the claims to the litigation of the claims to the concurrence, is the United States ever made to consider the environmental effects, even though that's precisely what NEPA requires.
Can I ask you about federal law? So after the 1954 Termination Act, but before the 1986 Restoration Act, wouldn't it have been obvious that the tribes owned and had a unilateral right to assert water rights?
Your Honor, I don't know. That may seem obvious as a matter of federal law. I do not know how the Oregon Water Resources Department.
How could it not be? I mean, the right is reserved, the trust relationship is extinguished, and yet the Extinguishing Act explicitly says this has no impact on the reserved rights. So who in the 1954 to 1986 world, who could possibly assert water rights other than the tribe's water rights other than the tribes unilaterally?
Yes, okay. So in the absence of that trust relationship, then yes, I suppose BIA would not be required to make the management decision.
Okay. So now we throw into the mix the Restoration Act, which reestablishes a trust relationship, which might tend to help you, which might at least set up the question of what's the nature of that trust. But the Restoration Act very specifically says that nothing in that statute shall affect in any manner any fishing or water right of the tribe or its members. So if they had the right, if they could have unilaterally asserted their water rights before the Restoration Act, it seems pretty obvious they can do the same thing after the Restoration Act, because there's a very specific clause addressing that question.
Your Honor, I disagree. I think that clause is better read to be talking about the substance of the rights. And it's true that nothing about the substance of the rights is changed. But the Mccarran Amendment, as I've said, subjects the administration of the rights to Oregon state law. And again, leaving federal law aside, I think it's key here that at the end of the day, it is the Oregon Water Resources Department who is issuing these calls. And they don't do so without BIA's concurrence. But
we can't leave federal law aside to the extent it is supreme. I mean, your argument about what the state is doing only works if, as a matter of federal law, the ownership of the water rights is a question of administration under Mccarran rather than within the scope of this reservation in the Restoration Act.
Well, Your Honor, I also think that I don't think that the United States government could force the Oregon administrative apparatus to implement its regulatory programs. That I think would be a violation of the 10th Amendment. It would be a commandeering issue. And for the purposes of standing and causation and redressability, it is the Oregon Water Resources Department that's issuing the shutoffs. And they don't do so without BIA's concurrence. And Your Honor, I think if you look at the government's brief, they move away from the issue of concurrence a little bit towards the issue of discretion. And I think that's because of the strength of the argument that the concurrence is required. You can also, by the way, look at the protocol itself, which I think is the government's biggest hurdle in trying to make both the arguments about concurrence and discretion. The protocol itself discusses, in exact terms, required concurrence. And the protocol also requires that when the tribes want to make a call, they have to submit their proposal to the Bureau of Indian Affairs with the reasons why they want to make a call. The Bureau of Indian Affairs then deliberates over whether or not they will agree, disagree, or want to change the scope of those calls. And the United States actually has the right in the protocol unilaterally to make a call, even over tribal objections. The very provision that the ranchers are challenging here.
But the more important point is that the tribe retains its independent right to make a call.
Sure, and the tribes are free to make calls to the Oregon Water Resources Department. But again, as a matter of fact, the Oregon Water Resources Department will not effectuate or implement those calls unless they've gotten some concurrence from the Bureau of Indian Affairs. And again, the question...
Excuse me, we can take that as a matter of fact?
Yes, I think so. And based on the emails, and I think also that we make the argument that it's a matter of Oregon administrative law in cases like the Fort Vinoy case. If you're not convinced on the legal question, perhaps it's an issue for certification to the Oregon state courts. But for the purposes of standing and causation, where the rubber meets the road is at the Oregon Water Resources Department, and they don't issue the shutoffs. They do not issue the shutoffs unless they have some concurrence from the Bureau of Indian Affairs.
Mr. Dearson, under the Restoration Act, when the statute speaks about real property, does that include water rights in your view?
Your Honor, I'm not sure. What about real property does the statute say that you're trying to ask about?
Well, I mean, for instance, it talks about real property in a number of contexts, and I believe there are some Supreme Court decisions suggesting that water rights are included with real property rights.
Yes, I think it's fair to characterize them as real property, although I'd also point out that they're a special form of property, and particularly in the Western United States, where they have the system of prior appropriation rather than, a pertinent water rights.
So I guess, putting aside the Oregon state law requirements, what is your strongest argument that under federal law, the government maintains the right to manage this water, even though the water rights are held by the tribes? What are the cases or statutes under federal law that, are your strongest case for that?
Sure. So I think those cases include the Shoshone-Bannock case, the Mitchell cases from the United States Supreme Court, and the White Mountain Apache case, in all of which the court spoke of the affirmative obligation of the United States to manage the trust assets in the manner that it believes appropriate. And that the tribes could not strong arm the United States as trustee into making the decisions that the tribes prefer. And furthermore, specifically with respect to NEPA, there are those cases at page 27 of the reply brief, including the Many Goats case, in which the 10th Circuit said, again, the interests of the government under NEPA may conflict with the interests of the tribes, and the government still must follow the strictures of NEPA. I'd also point out that Congress, charged the Department of Interior and the Bureau of Indian Affairs with the management of Indian affairs. And when it comes to management decisions that have such serious environmental impacts, those certainly seem to be the type of major decisions which Congress has placed in BIA and Interior, and which Congress has not permitted to be delegated beyond the bounds of those agencies.
So you think it's impermissible for the government to decide to exercise its management authority, its discretionary management authority, by leaving those decisions to the tribes?
By leaving them wholesale to the tribes, yes, Your Honor, I do. I think that's the ruling from FCC v. Telecom, or rather from the U.S. Telecom case from this court, as regards the general non-delegation argument. And then, I think that the case law I've cited supports the notion that when it comes to NEPA considerations, it must be the government that makes the considerations. They certainly can and should incorporate, the tribes' position as an element of their decision making, and certainly the tribes are in a good position to know or to have a good information about what level of in-stream flows will be necessary in a given instance. But no, Your Honor, they cannot wholesale delegate that decision-making authority. And that's all that the ranchers are seeking here. Again, at no point has the government been made to consider the serious environmental crisis that they're facing. And all they ask is that somebody who's politically accountable to them, somebody in the government, be the one who's finally making these decisions, and that the government not pass the buck on to the tribes, as it were.
All right, why don't we hear from counsel for Appellate, and we'll give you a couple of minutes on rebuttal.
Thank you.
May it please the court, John Smeltzer for the Department of the Interior. Your Honor, the linchpin of this case is the question of the scope of the tribe's authority to manage their own water rights. Under federal law, the Klamath tribes are a sovereign entity with the power and authority to exercise and control their own water rights. In the protocol agreement, the tribes agreed to consultation and coordination with BIA before making a call on their water rights. But the protocol agreement didn't give the tribes their authority to exercise their water rights or to make water rights calls. And for that reason, all of the plaintiff's claims fail. They lack standing because there is no injury traceable to the protocol agreement. And their claims on the merits fail because there's been no delegation of authority. So there's no implication of the non-delegation doctrine. And there is no federal action that has the possibility of having environmental effects for which there needs to be a NEPA review. Even if, Your Honors, this court were to decide that somehow the United States and BIA does have management authority over the exercise of these rights, though the plaintiff's claims still fail because the non-delegation doctrine does not apply to a revocable assignment of a property right, nor does NEPA apply because there's a clear NEPA exemption, which counsel did not address.
Mr. Smeltzer, if I can ask you the same question, similar question to what I asked Mr. Dearson. So in the government's view, what is the nature of the trust relationship between the government and the tribes here, right? What is the government's obligations or rights and responsibilities as trustee for these water rights?
Sure, Judge Round. And this is the classic case of a limited trust. These are real property rights that the tribes reserved unto themselves and which were reserved for them in the 1864 treaty. And the United States government and United States law recognizes the tribes as sovereigns with rights of self-government and control over their own interests, including their own property rights. So the trust designation with respect to the property rights, including the water rights, is largely a designation as to whether those rights can be alienated and the nature of the rights. The rights are ultimately held by the United States in perpetuity for the tribal interests, so the tribe can't alienate the rights. But beyond that limited designation, in order to have a trust obligation under federal law, there has to be a statute that imposes them.
Well, so why, in your view, does the Restoration Act not impose a broader trust obligation?
Because it just restores the standard trust relationship that would exist between the United States and a tribe with respect to its reservation, its reserved rights, and its water rights originally. And as Judge Katsas pointed out, there was a Termination Act in 1954. The tribes went to court, asserted their water rights. The Ninth Circuit determined that they had full control over those rights, and those rights existed. So there's no question about that. And the 86 Restoration Act said it wasn't going to impact pre-existing rights.
Well, but the thing is, I think, so the Adair case from the Ninth Circuit, right, is decided in between these two times when there is no trust relationship between the government and the tribes. And so it seems to me that the language of that case talking about control is all in the context of there not being a trustee relationship. And so I think, we have to look at, what type of control might have been reestablished by the Restoration Act.
Sure, Your Honor. And if you take away the Termination Act, take away the Restoration Act, and just treat it as though it were tribal property throughout, the same result, you get to the same place. Because under federal law, the property rights of the tribe are theirs to control and exercise. The only exception to that is when Congress steps in and provides a specific management authority that may lead to a particular obligation, a trust obligation.
Well, what about in the Restoration Act, the authority under Section 8 for economic development? That the secretary shall put forth a plan for economic development. Does that give the government some greater role as a trustee?
I don't believe it would be sufficiently specific to give rise to any particular obligation. Certainly, that gives the BIA discretion to work with the tribe.
It's not a discretionary duty. It says that it shall submit such a plan.
Right. I don't think there's any suggestion that the government's broad authority or obligation to assist with the tribe and to develop a particular plan for the tribe is contrary to the idea that the tribe retains its sovereign powers and authorities over its own water rights.
I just think that you're answering a different question from the one that I'm asking. It doesn't seem to me necessarily true that because they're a sovereign and because they have property rights, that means the government doesn't also have some obligation as a trustee to exercise some fiduciary control over how the tribes exercise those rights. And so I want to understand why the government's position is that it has no fiduciary role essentially in this trust relationship. And I guess that's the question that I feel like is not getting answered here.
Right, Your Honor. Sorry, Your Honor. Let me try again. The United States Supreme Court has held that federal trust obligations, fiduciary obligations to tribes, are obligations that derive from statute. They do not. There is no specific trust obligation writ large that gives the United States either the authority or the duty to manage tribal resources. They derive from statute. That's United States versus Hickory Apache Tribe, which is one of the most recent cases to address that proposition. So all of the cases that counsel cited about where there were some trust obligations found were all cases where there were statutes with a trust duty imposed. The White Mountain cases are cases where there are statutes and regulations that require the government specifically to manage timber resources. And in that context, then, of course, the tribe's sovereign control over its own timber resources are reduced to some extent. And the government has then the fiduciary obligation as manager of the corpus to ensure that that resource is managed productively for the tribe. But that derives from those particular set of statutes. And in the Mitchell line of cases, the Supreme Court specifically said that there is no obligation and there is no trust duty except that duty that are accepted and acknowledged by statute. The trust designation generically, the limited trust that exists for any federal reservation or property rights that belong to the tribes that were reserved by the tribes themselves, is again largely just a designation with respect to alienation and the extent to which the rights can be alienated, and also a reference to Congress's plenary authority, right, to step in and to legislate if Congress chooses to provide a scheme for management of rights. But there is no such scheme in this case. And again, the cases that are cited in the plaintiff's brief are cases where there's either a statute or where the United States is being called under the Mccarran Amendment to adjudicate tribal claims, because the United States Supreme Court has held that the Mccarran Amendment, even though it doesn't say so on its face, applies to Federal Reserve rights that are held on behalf of tribes, and therefore the government has, when it adjudicates in a Mccarran Amendment adjudications, has some obligation and authority to assert claims on behalf of tribes. Judge Katsas?
Yes, suppose I agree with you that as a matter of federal law, the tribes have unilateral control over their water rights. It still seems that the Oregon State Agency has taken a different position, and we can't review or reverse their decision. So for standing purposes, don't we have to take as a given that on their understanding of the law, even if we think it's wrong, the government needs to concur in the call in order for the water right to be enforced?
Your Honor, I don't think so, because there's been no formal legal determination. And also, let me address the notion that it's a factual question. It's not.
I'm sorry, the notion that I didn't hear.
That it's a factual issue,
Okay, right.
that for which this court defers to some sort of factual determination. I mean, it's not a factual issue; it's a legal issue as to whether there's a concurrence requirement. And so, what we submit to the court is there is no concurrence requirement under federal law for reasons we have just talked about. There's also no federal concurrence requirement under state law, and those issues were briefed by both sides. Plaintiffs point to the Fort Lenoir case, which was not a case about calling on water rights. It was a case about transferring the place of use of water rights under a statute that specifically addressed or used the term the holder of a water right, and said the holder has to concur in that, and that state court.
Suppose I also agree with you that it's a legal question rather than a fact question. We still have indicia from the Oregon agency tending to show that rightly or wrongly, they think as a legal matter that concurrence is required.
Well, sure, but if this court were to affirm what is the law, which is there is no concurrence requirement, I have no expectation that the Oregon state officials would disagree with the judgment of this court. And even if for some reason they were, that doesn't change the sort of legal causation that's required, both for standing and specifically for NEPA.
Well, I mean, but standing is injury in fact. And even if we were completely right in our conviction that the tribe unilaterally controls these rights, and even if the state agency were completely wrong in its conviction to the contrary, as a matter of fact, their issuance of their enforcement of the water right will depend on whether or not the United States concurs in the tribe's call.
Yeah, and again, what I would say, Your Honor, is that causation, even for standing, this court has suggested that sort of but-for mechanical causation is not sufficient. But if this court were to determine that for that mere reason, because there are employees of the Oregon Water Resources Department who are not following federal and state law in terms of honoring the calls from the tribe, that provides standing here. There clearly is still not a claim under the non-delegation doctrine because there's no authority that's been delegated. And there's also no claim under NEPA because under the Supreme Court's ruling in Public Citizen, it's absolutely clear that you need legal causation to have a NEPA claim. There has to be more than just but-for causation. The United States has to have some discretionary authority over the action, or the agency has to have discretionary authority over the action which is subject to NEPA. And so, even if like I said, there's some sort of mechanical standing, there would not be a valid claim under either theory of the case that the plaintiffs are putting forward here. I would also argue or advise the court, in addition, that if somehow there was some authority that had been delegated or is being exercised here, there's still not valid claims because this is not a case like US Telecom where there's a delegation of regulatory authority. This is simply an assignment, a revocable assignment of a property right by, if it's the case, a trustee who has authority over it to the beneficiary in a context where there is no suggestion or possibility of a violation of a fiduciary trust in providing a revocable assignment of a property right to a beneficiary. There's no precedent or law that would support the idea that somehow implicates a non-delegation doctrine, delegation of regulatory authority like in U.S. Telecom. And then also with respect to the NEPA context, of course, there's an express exemption for water right or for civil enforcement actions, and a call system exists solely to enable enforcement of adjudications and judgments in water rights cases. On its face, that exemption applies to what is happening here. And what the court has to keep in mind with respect to that exemption is the purpose for the exemption, and the purpose is that you can't plausibly do NEPA in the context of civil litigation and applying an injunction, and also the purposes of what a civil enforcement action does is preserve the status quo. And again, we're talking about in-stream water rights. That the exercise of the tribe's right means that those flows remain in the water, and the junior water users, plaintiffs or others, are unable to take water out of the system. And so that's simply maintaining the status quo, and it falls clearly on the face squarely within the NEPA exemption. I see my time has rolled over. If the judges have any other questions, I'd be happy to answer them.
All set.
Anything further? Judge Rao?
All set.
Thank you, counsel.
Thank you.
Here for counsel for appellants.
Thank you, and may it please the court. I think that there's been a lot of discussion regarding the concurrence requirement and discussion to the effect that perhaps the United States concurrence is not required as a matter of federal law or even as a matter of state administrative law in order to effectuate the water rights. But again, I think when you're deciding this case, which is challenging the protocol amendment, probably the first thing you'll look at is the protocol itself, which speaks of required concurrence. The very provision that the ranchers are challenging is one in which the government promises not to withhold required concurrence. And I think the implication is quite clear that its concurrence would be required, at least in some circumstances. And furthermore, that absent such a promise, it may have reason to disagree with the tribe's decision to place a call, or even just the scope of a call in a given case, and that it may actually withhold such concurrence. And as far as competing obligations, specific competing obligations of the United States, in terms of interests that it has to balance, again, the Klamath Treaty, from which the water rights derive and which created this trust relationship, one of the purposes of the Klamath Treaty was to promote agriculture. And the deleterious effects, the deleterious environmental effects here may well frustrate that purpose of promoting agriculture. Although I'll admit, frankly, it's somewhat hard to say, again, because the government is avoiding its obligations under NEPA to consider those effects. And with the ranchers succeed in this case, all they're trying to do is to restore some measure of political accountability where there currently is none. Again, at no point in this process was the government made to consider the serious environmental harms being done to the ranchers and to the Upper Klamath Basin agricultural community generally. And perhaps the NEPA analysis reveals that the tribes should get precisely what they ask for. But I think the fair implications from the allegations in our pleadings is that some balancing may be appropriate, and that the United States could, in fact, arrive at a position that preserves enough water for the tribes to have their fishing rights while still permitting sustainable agriculture in the region.
Thank you, counsel. We'll take the case under advisement.
Thank you.
This honorable court is now adjourned until Tuesday, December 1st at 9:30 a.m.